international passport or travel document. However, this document and this program for stateless persons in Canada is problematic because one, it is only for permanent residents and not other stateless persons in Canada who are otherwise lawfully staying but need a travel document. And two, the travel document is said to not be valid for the bearer's country of citizenship, which is a bizarre requirement given stateless persons do not have a citizenship. And it's further unjustifiably restrictive for stateless persons who are not refugees and do not fear persecution, and there's no issue of reavailment to their country of origin to be considered. So in light of these issues, the Canadian legal framework does not appear to be fully compatible with Article 28 of the 54 Convention. So just in conclusion, although I didn't really get into the compatibility aspects, there are some aspects of the Canadian legal framework that are compatible with the 54 Convention, but by highlighting the incompatibilities, I think it's quite obvious that Canada's key rationale for not acceding to the 54 Convention, that its legal framework is compatible, is perhaps not entirely accurate. And such gaps could be best addressed by accession to the 54 Convention, improved adherence to international human rights law obligations that Canada already has, and a coherent policy approach by both the federal and provincial governments towards the unique needs and circumstances of stateless persons.
Thank you very much. Thank you for being so disciplined, and I appreciate that, and this will give the audience and everyone the opportunity to engage into a very interesting debate. So I'm going to open it now. Just a couple of ground rules. I have just seen that there are some microphones, so actually you don't have to wave your hands. Just if you want to go and speak on the microphone. And before you do that, please don't forget, of course, to state your name and affiliation. And don't be shy. That's the opportunity for you to speak and to also ask clarification. So, yes? Okay, so maybe if you can go maybe on the microphone, if that's okay with you.
My name is Zach Salanjar. I work with the Canadian Center for Victims of Torture. I have been monitoring the plight of stateless people for the last 30 years. And I speak with you today as a frontline worker. First of all, I have one question from UNHCR. I want to know about foreigners, people who are de facto stateless with no rights in countries like China and Japan. This is my question, simple question. And now my comment. I want to share with you about some of my clients. Very, very recently, I had a client who was released from detention after 6.5 years because of being stateless. I'm sorry, After 6.5 years in detention, going through torture and all kinds of degrading treatment and punishment, because there was no country to send him to. I had another client who were deported 4 times, and then they couldn't deport him anymore. Many years in detention in Canada. And finally they said, okay, we give you HNC, and for HNC you should provide passport. there was no state to give him passport. It was catch-22. Very recently, a client of mine was born in Syria, and then with father and grandfather in Afghanistan, he was rejected by IRB. So again, fortunately, we won the case in the appeal. I have now 3 clients born in Saudi Arabia from Eritrea, no country. I'm very concerned about them. And that is, I think the problem is de facto stateless people in Canada. So we have many people in limbo. So they just, yesterday, one person came to me, he was accepted as a convention refugee in 1992. I told Andrew. So in limbo, no state, a de facto stateless people, and we have plenty of people in limbo. And they cannot send them anywhere, and they don't give them any status. And also one more issue is the new Canadian legislation and practices, specifically for people suffering from mental health. They have made it so difficult, and the new government has not made any change. That it goes to Ottawa, there are lots of requirements, we get a psychiatric report, there's no attention to their citizenship. We are creating a statelessness in Canada too. I have 3 suggestions for this statelessness coalition and for all of us. 1, please do something for Canada to end the limbo. 2nd, we need to change this new legislation and specifically practices. It should be done immediately. 3rd, ratification of 1954 convention. But I want to tell you one thing that is not adequate, because 1954 convention is minimum standard, even is not at par even with refugee convention. Thank you very much.
Yes, sure. So let's take a few questions and then the comments for later. Yes.
Clara Jimeno, a researcher. I have 2 comments and questions, and they are very linked to the previous comment. One is, it seems that countries can act with impunity with treating stateless persons. So it seems that countries can act with impunity treating stateless persons. So you discuss different kind of instruments, but what if UNHCR has a way to condemn or to punish countries that are doing that? Particularly, for example, the case mentioned on Australia, how they are treating the Syrian refugees at this moment. But the other comment I have, and is also related to the human cost of the treatment received by the stateless persons. What is the cost on physical and psychological health? You have discussed about all the instruments, but is there some research doing about that, having a person 10 years in detention or 7 years? So we are talking about instruments, but there are people involved there, and there is an impact, and this is a human cost for the countries, for the world.
Maybe I will let you briefly comment if you want, and then take another couple of questions.
Well, I mean, I can surely pick it up from the last remark of Madame, respect to the cost of statelessness, because it is actually, you are making a direct reference to what I've said in my opening remarks with respect to the imperative of development, the development and peace-building imperative of solving statelessness, to the fact that it is clearly evident from research and from the direct experience of the individual case who are unfortunately in that situation, which is a tremendous waste of resources. And statelessness is actually an impediment to development and the peace-building imperatives of the society. So the fact of keeping people in detention for a long time without a court of law and without legal basis for that, it's evident not only on the statelessness particular situation, but actually this is an area which has been particularly impacted by the large phenomenon of irregular movement and displacement and migration, including asylum seekers. We have seen all over the world countries reacting to displacement with actually more enforcement measures in terms of detention. The first reaction now to global displacement in certain parts of the world is an immediate automatic detention for the people who are coming in an irregular manner. So the issue of detention as a response to movements of people it's a global, it's larger. It affects stateless persons, it affects asylum seekers, it affects migrants. And UNHCR is present in that respect, with the particular focus, of course, with respect to our mandate on asylum seekers and stateless persons. But UNHCR is also a global campaign, which is actually called Beyond Detention, trying to solve the problem and going beyond the fact of using detention as a response to migration. And Canada is part of this global strategy beyond detention. We are working with partners, government and non-government partners, and the challenge anyhow is there. It's not that the fact of having a strategy in itself doesn't solve the problem. The strategy wants only to create a way of working together in order to tackle those issues. Having children in detention is particularly painful and is particularly wrong for all sorts of obvious reasons. There is a society like Canada provides the opportunity to offer alternatives to detention, which is an enormous area in which we are trying to promote and enlarge those possibilities. So work is being done there, and detention is a very serious issue which unfortunately impacts beyond the category of stateless persons.
Obviously, I share the concerns, and is that we've talked many times about limbo and statelessness are sometimes related, they sometimes overlap, and they're also distinct. But I think that there needs to be more movement and more research on that particular issues and the ways to resolve it. I do take some comfort. Last night I was watching CPAC, because I am that person, and I saw Minister McCallum before the committee on Immigration, Refugees and Protection, talking about his deep concern about lengthy processing times and his need, his commitment to find ways that the department can speed up processing of applications for family reunification, but also cases inland. That deals with a huge part of both detention issues as well as limbo generally. Just very quickly on the issue of detention, I would not specifically of people who are stateless, but people whose nationality may not be resolved. We don't know whether they're stateless. Do take a look at the report by the International Human Rights Program called We Have No Rights. It's a very compelling, well-researched report on detention and mental health. But it deals not just with the mental health issue, but also conditions of detention, circumstances, reasons for detention. And if this is an area that you want to do more research in, then please come and talk to me. There are groups in Toronto looking at long-term detention. There's test case litigation happening in that area very specifically. And working with some of you on statelessness in detention and establishing nationality, I think would be really helpful for that sort of movement to deal particularly with detention.
I would just mention that on the issue of de facto statelessness and whether or not the 54 Convention is adequate. Yes, it provides a very low threshold of rights that could be provided. But the final act of the 54 Convention encourages states to treat de facto stateless persons as they would de jure stateless persons. So perhaps even though it's kind of a low bar in terms of the minimum treatment, that we're acceding to the convention can still provide some movement towards the positive treatment of de facto situations as well.
First, I just want to thank all the presenters for the fascinating sort of overviews of different areas, which are really important to attend to. Now, I think the focus of the UNHCR's statelessness campaign and the statelessness unit to address gaps in legal protection mechanisms and gaps in nationality law is really important in terms of addressing the generation of statelessness to the operation of law, or the lack of the control of nationality in doing so. But the one thing which I want to sort of turn to is actually something which was addressed in the second presentation, which is the apparent resurgence of denationalization by the part of governments as a potential source of generating statelessness. And the reason I want to sort of bring this up is because it's not just Canada which is now sort of introduced this provision, but other countries as well. France is now, for instance, contemplating using the stripping of nationality with regard to its citizens, and I believe the UK is also has such a provision. So what we're witnessing is kind of the resurgence of denationalization as a sort of legitimate action of states, which of course has sort of roots and connection to the emergence of statelessness historically as a sort of mass phenomena. Now, while there are legal protections in place in some cases with regard to sort of international law commitments, as was alluded to in the second presentation, often the construal of whether a person possesses another nationality is very hard to determine. And part of the reason for that is that recognition of nationality by another state is still within the reserved jurisdiction or national domestic jurisdiction, right? So I wonder whether the existing legal instruments for addressing statelessness can fully address the sort of tension between the ability of states to still claim the right to strip citizenship and the inability of them to control whether or not that individual possesses nationality somewhere else, and whether we need further governance mechanisms to address that gap.
Do you mind stating your name? Sorry.
Karen Banerjee from the University of Toronto.
Sure, I think that's a hugely interesting issue. I don't know whether it's in this version of the paper, but in the 2003 version of the paper I did for UNHCR, I proposed probably a really wacky idea of having a global tribunal that would have responsibility to determine nationality where nationality was in question. I mean, it requires all sorts of things to happen first, including that everybody sign on to the 61 Convention minimally. But I think you're right. There's a real gap there. Who decides? I mean, obviously each state decides on its own nationals, but in a world where everybody's born somewhere, everybody needs to have some nationality. The idea that you can simply revoke national status of someone within your border, someone who's one of your nationals, seems anathema. It's just directly contrary to basic human rights principles. So I think that's an interesting idea. I don't know whether that's something that would ever happen, but
yeah, and there are provisions in that respect. The area of renunciation and deprivation of nationality is covered by the 61 Convention, and there are provisions which are in relation to loss and renunciation and deprivation of nationality. for which it is permissible under certain particular circumstances. So it's very important that provision existing in the present international legal framework be respected, and of course including the fact that are valid only according to the existing conventions. They can be applied only if at the time of accession the country has made a specific declaration in that respect. But there is a general trend in that respect, of course, that is, as you have acknowledged, and this is worrying. It's worrying because, for what I all said from the very beginning, again, it goes against the fact that the world is organized in nation states, and it's very strange again that there are people who do not belong to this particular order. The issue of not creating statelessness, of course, is the most crucial factor in that respect. There may be degradation of nationality when it comes to dual or multiple nationalities, and the standards for which it has to be respected is that degradation of nationality should not create statelessness. So maybe it may be seen in the context of multiple nationalities, but the bottom line is it should not be creating statelessness.
Okay, so it's already, maybe do we have time for our last question? Or? Okay, if you can be very prompt and identify yourself.
Have to raise this back up. My name is Robert Addington. I'm part of Don Chuckman's group, the Lost Canadians, and we try to help Canadians who are either excluded from citizenship or are having difficulty claiming it because of anomalies in the citizenship law. You'll be hearing from Don this afternoon, so I don't want to replicate anything he may have to say. But I will say just this. Our group has done a lot of research on the history and development of Canadian citizenship before and since 1947. So let's go back to 1946. In April of 1946, almost 70 years ago, Paul Martin Sr. Moved second reading of the Canadian Citizenship Bill in the House of Commons. And in the last paragraph of that speech, it includes a sentence that I've committed to memory. Citizenship is the right to full partnership in the fortunes and the future of the nation. 16 words I've counted. I believe that sentence should actually be written in to the next revision of the Citizenship Act. Paul Martin, who was a lawyer and a smart politician, got it right. He understood that citizenship is about belonging, inclusion. Conversely, statelessness is about exclusion. Exclusion from the community of nations and from the rights that we all take for granted as citizens, as Jocelyn Kane pointed out in her opening remarks. So here's a second sentence I'd like to see in the next revision of the Citizenship Act. Nothing in this act shall be so interpreted or applied as to render any person stateless. Finally, I have one question for Furio. It has to do with a word that you used in your presentation, the word autochthonous. That's a technical word that may be unfamiliar to some people here. I understand it to mean as any group that is clearly identifiable by such characteristics as language, or ethnicity. So perhaps you could clarify that for us.
Very quickly, I would say that this is part of the causes of statelessness, as I said, in relation to discrimination and discriminating certain groups existing already in those in the territory of states. And then I mentioned certain countries in which statelessness exists because groups which have already been existing there are not granted the rights of citizens. So this as opposed to other situations where actually cause of statelessness is because of migratory movements, like in Ivory Coast or in the Dominican Republic, where actually was the result of migrations and generations after statelessness again on the basis of discrimination was then the result of that. So it was only a way to distinguish the fact of migration movement plus discrimination as opposed to existing population plus discrimination. That was the intention.
Thank you very much. Let me thank everybody for being here, and I want to thank in particular for you and Andrew and Greg and all of you for the stimulating debate. Thanks very much.
All right, now that our first panel is wrapped up, I would again like to thank Greg for all the hard work on the report. If you all are interested, as he already alluded to, they are located on your desks. So it looks just like this, and you're free to take home a copy. The recommendations are located in the back, and Greg talked extensively about them. We're going to take a coffee break now. We're slightly behind schedule, so in an attempt to pick up the schedule, we're going to have a 5-minute coffee break. So I just want you to take 5 minutes to get a coffee, get some food, and I'd also like to let you know just quickly that we have a Wi-Fi password. So Wi-Fi access is U Ottawa guest, and the password is GU Ottawa. So we're going to take a 5-minute break, and we'll be back in just 5 minutes.